Welcome to Icon Health and Fitness Sexual Harassment Prevention Training. Sexual harassment is a form of sex discrimination that violates Title VII of the Civil Rights Act of 1964, a federal law. Icon does not tolerate any form of sexual harassment. This training is designed to provide employees and supervisors with information and practical guidance concerning the prohibition of any unlawful harassment in the workplace, but will focus on sexual harassment. This presentation explains what sexual harassment is under both federal and state laws and also covers Icon's anti-harassment policy, the responsibilities of supervisors and managers, supervisor and individual liability for sexual harassment, what constitutes retaliation, and why it is prohibited. It also includes training on prevention of abusive conduct in the workplace and prohibition against harassment based on gender identity, gender expression, and sexual orientation. Title VII prohibits discrimination on the basis of sex, including pregnancy and gender nonconformity, race, color, religion, and national origin or ethnicity. Title VII prohibits adverse employment actions against protected classes, which would include termination, failure to hire, and demotion. Sexual harassment is a form of discrimination that violates Title VII. It includes any harassment based on someone's sex or gender. It's any unwelcome sexual advance or conduct of a sexual nature when any of the following is true. The employee's submission to the advance or conduct is made explicitly or implicitly a condition of employment. The employee's submission to or rejection of the advance or conduct is used as a basis for employment decisions, or the advance or conduct unreasonably interferes with an employee's work performance by creating an intimidating, hostile, or offensive work environment. The federal definition of sexual harassment is defined by the Equal Employment Opportunity Commission, or the EEOC, and it includes unwelcome sexual advances, requests for sexual favors, and any other verbal or physical conduct of a sexual nature. This conduct violates Title VII if it affects one's employment, unreasonably interferes with one's work performance, or creates an intimidating, hostile, or offensive work environment. There are two types of sexual harassment: quid pro quo and hostile work environment. Quid pro quo is Latin, meaning this for that. Quid pro quo harassment is characterized by explicit or implicit conditioning of a job or promotion on an applicant or employee's submission to sexual advances or other conduct based on sex. Quid pro quo harassment also occurs when an employee's reaction to a sexual advance negatively affects his or her employment. The more common type of sexual harassment is hostile work environment harassment. Hostile work environment sexual harassment occurs when unwelcome comments or conduct based on sex unreasonably interfere with an employee's work performance or create an intimidating, hostile, or offensive work environment. The standard that is set for whether something constitutes sexual harassment is the severe or pervasive standard. So what does it mean that the unwelcome conduct has to be sufficiently severe or pervasive to constitute unlawful sexual harassment? Well, here's an example. Suppose an employee named Susie mentions to you that a coworker, Mark, asked her out on a date, but that she turned him down and said she had a boyfriend. Would a single date request be considered severe or pervasive? What would you do in this situation? What, if anything, should you do? What if Susie tells you that Mark keeps asking her out? Now she feels uncomfortable and tries to avoid him, but he comes by her cubicle all the time and asks if she's broken up with her boyfriend yet. Once, Mark massaged her shoulders, which she did not like. What would you do in this situation? Sexual harassment is not limited to one type of conduct. It can be any conduct that rises to the level of being severe or pervasive, including physical, verbal, or visual. It need not be targeted at the offended individual to give rise to a hostile work environment claim. For example, having sexually explicit conversations at work where coworkers are present or can hear the conversation constitutes sexual harassment. Harassment does not have to be motivated by sexual desire to be unlawful. Here are some examples of physical conduct that may constitute harassment: assault in the most extreme form, unwelcome touching, impeding or blocking movements, any physical interference with normal work or movement, sexual gestures, or coercing another person to participate in sexual intercourse or other sexual behaviors. Some examples of verbal conduct that may constitute harassment include foul or obscene language, making derogatory comments, slurs or discussions about sexual activities or behaviors, comments about another person's physical attributes, spreading rumors about another person's sexual activities, conduct, or partners, jokes, including those about gender-specific traits, sexual advances, and sexual innuendos or double entendres. Some examples of visual conduct that may constitute harassment would include leering, such as slowly looking someone up and down, making sexual gestures, displaying sexually suggestive or explicit objects, pictures, cartoons, or posters, or computer games depicting sexual situations or behaviors. Some examples of written conduct that may include harassment include suggestive, obscene, or propositioning communications in the form of letters, notes, greeting cards or incitations, or emails or text messages. So who can be a harasser? Supervisors, coworkers, customers, clients, vendors, individuals or groups doing business with a company or on the premises can all be harassers. A harasser's intent is irrelevant. Sexual harassment may be unlawful even if not motivated by sexual desire. The gender of the harasser is also irrelevant. Men can harass women, women can harass men, men can harass men, women can harass women. And harassment is not limited to the workplace. Sexual harassment can occur outside the workplace, for example, during company-sponsored annual meetings, business trips, holiday parties or sporting events, and can also occur via email or text, either during or after work hours. ICON's anti-harassment policy is this: all unlawful harassment is prohibited. ICON is committed to providing a workplace that is free from unlawful harassment. ICON strictly prohibits and does not tolerate unlawful harassment against employees or any other covered persons, including interns, because of race, color, religious creed, national origin, ancestry, age, 40 and over, sex, marital status, sexual orientation, gender, gender identity, gender expression, genetic information, medical condition, mental disability, physical disability, past, current, or prospective service in the armed forces or uniformed services, or any other characteristic protected under applicable federal, state, or local law. ICON also prohibits and does not tolerate unlawful harassment against employees who are perceived to have these characteristics or who associate with a person who has or is believed to have these characteristics. Harassment can occur in the workplace, after hours, or on social media. The law, as well as ICON's policy, prohibits harassment by coworkers and third parties, as well as supervisors and managers. It should always be reported and will not be tolerated by ICON. All ICON employees, other workers, and representatives, including vendors, customers, subscribers, clients, and visitors, are prohibited from harassing employees and other covered persons based on that individual's sex, including that individual's pregnancy, childbirth, breastfeeding, or medical conditions relating to pregnancy, childbirth, and breastfeeding, sexual orientation or gender, including that individual's gender identity or gender expression, and regardless of the harasser's sex or gender. Sexual harassment within ICON's policy means any harassment based on someone's sex, gender, gender identity, gender expression, and sexual orientation. It includes harassment that is not sexual in nature, for example, offensive remarks about an individual's sex or gender, as well as any unwelcome sexual advances or requests for sexual favors or any other conduct of a sexual nature when any of the following is true. Submission to the advance, request, or conduct is made either explicitly or implicitly a term or condition of employment. Submission to or rejection of the advance, request, or conduct is used as a basis for employment decisions, or such advances, requests, or conduct have the purpose or effect of substantially or unreasonably interfering with an employee's work performance by creating an intimidating, hostile, or offensive work environment. ICON will not tolerate any form of sexual harassment, regardless of whether it is verbal, for example, epithets, derogatory statements, slurs, sexually related comments or jokes, suggestive or obscene letters, unwelcome sexual advances or requests for sexual favors, physical, for example, assault, inappropriate physical conduct, or impeding or blocking movements, visual, for example, displaying sexually suggestive posters, cartoons, or drawings, sending inappropriate adult-themed gifts, leering or making sexual gestures, or retaliatory, for example, threatening retaliation or taking retaliatory action. This list is illustrative only and is not exhaustive. No form of sexual harassment will be tolerated. Harassment is prohibited at the workplace, at employer-sponsored events, and on social media. ICON's anti-harassment policy applies equally to other unlawful harassment that's not sexual but is based on an employee's race, color, religious creed, national origin, ancestry, age of 40 and over, marital status, genetic information, medical condition, mental disability, physical disability, military or veteran status, gender, gender identity, gender expression, and sexual orientation, or any other characteristic protected under applicable federal, state, or local law. Such other harassment often takes a similar form to sexual harassment and includes harassment that is verbal, for example, epithets, derogatory statements, slurs, derogatory comments, or jokes. Physical, for example, assault or inappropriate physical contact. Visual, for example, displaying derogatory posters, cartoons, drawings, or making derogatory gestures. Or retaliatory, for example, threatening retaliation or taking retaliatory action. Again, this list is illustrative only and is not exhaustive. No form of harassment will be tolerated. Harassment is prohibited at the workplace, at employer-sponsored events, and on social media. ICON has internal complaint procedures. If you are subjected to any conduct that you believe violates ICON's anti-harassment policy or witness any such conduct, you must promptly speak to, write, or otherwise contact your direct supervisor, or, if the conduct involves your direct supervisor, the next level above your direct supervisor, as soon as possible after the offending conduct takes place. ICON will ensure that a prompt and thorough investigation is conducted. Your complaint should be as detailed as possible, including the names of all individuals involved and any witnesses. ICON will conduct a fair, timely, and thorough investigation that provides all parties appropriate due process and reaches reasonable conclusions based on the evidence collected. ICON will take prompt corrective action if appropriate. ICON will maintain confidentiality to the extent possible. You will be informed of the results of the investigation. Additionally, any manager or supervisor who observes harassing conduct or receives a complaint of harassment must report the conduct to the Human Resources Department so that an investigation can be made and corrective action taken if appropriate. ICON is committed to enforcing this anti-harassment policy. The effectiveness of our efforts depends in part on employees telling us about inappropriate workplace conduct. If you feel that you or someone else may have been subjected to conduct that violates this policy, you should report it immediately. If employees do not report harassing conduct, ICON may not become aware of the possible violation of the policy and may not be able to take appropriate corrective action. No one will be subject to, and ICON prohibits, any form of discipline, reprisal, intimidation, or retaliation for good faith reporting of incidents of harassments of any kind, pursuing any harassment claim, or cooperating in related investigations. Any employee, regardless of position or title, whom the Human Resource Department determines has subjected an individual to harassment or retaliation in violation of this policy will be subject to discipline, up to and including termination of employment. The Human Resource Department is responsible for the administration of this policy. If you have any questions regarding this policy or questions about harassment that are not addressed in this policy, please contact the Human Resource Department. This policy is not intended to restrict communications or actions protected or required by state or federal law. So what about romance in the workplace? In order to minimize the risk of conflicts of interest and promote fairness, ICON maintains the following policy with respect to romance in the workplace. Romantic or dating relationships between employees are permitted, but only under the circumstances described by this policy. All employees engaged in a romantic or dating relationship must notify Human Resources. Individuals involved in a relationship covered by this policy may be asked to sign a document acknowledging that their relationship is free from coercion and harassment. Employees are expected to conduct themselves in a professional manner at all times. Workplace dating or romantic relationships must not interfere with any employee's professionalism, including treating others with respect and refraining from behavior that may make others feel uncomfortable, for example, overt physical displays of affection and using sexual language. In particular, management personnel are expected to set a high standard of professional conduct both at work and at any social settings and events sponsored by ICON. For this reason, management personnel are prohibited from social interaction with subordinates that is or might be perceived as inappropriate. For example, unwanted flirting, touching, or other behavior that may be regarded as sexual harassment. ICON retains discretion in its enforcement of this policy. Decisions made under this policy will be based on operational and business reasons and without regard to sex, race, color, religion, creed, age, 40 and over, national origin, citizenship, physical or mental disability, military service or application, or any other protected characteristic under federal, state, or local law. Let's look at an example. Laura is very attracted to her boss, Will. Since they're both single, she asks him out for after-work drinks. After proceeding to dinner and having a few too many drinks, they go back to Laura's apartment, and Will ends up spending the night. Are there any potential problems here? What are the factors to consider? Could this be considered sexual harassment? Well, based on the few facts in the hypothetical, this situation appears to be mutually desired by two consenting adults. Whether or not a romantic relationship is allowed depends on a variety of factors. Even though ICON's policy does not expressly forbid supervisors from dating their subordinates, the situation does raise some significant legal exposure for the company and for Will. Because Will is Laura's boss, Laura could later allege that she felt pressured to sleep with Will in order to keep her job, or for a number of other job-related reasons. Employers and supervisors should be aware of how their sexual relations with a subordinate could have detrimental effects on themselves, as well as the company. Reporting procedures and supervisors' responsibilities. Supervisors should be knowledgeable about ICON's harassment policy and reporting procedures. Supervisors should communicate the policy and reporting procedures to all employees reporting to them or under their control. Employees should be directed to report complaints immediately to either the employee's direct supervisor, to the Human Resource Department, or to the Legal Department. Supervisors should report all employee complaints to Human Resources. Supervisors should respond promptly and appropriately to complaints or questions about discrimination. If you're not sure what to do, contact the Legal Department or Human Resources. Although confidentiality will be maintained to the fullest extent possible, supervisors should never guarantee confidentiality of reports or investigations about reports. Supervisors should maintain a respectful workplace and not permit inappropriate behavior to go unchecked. Human Resources should be consulted when one is uncertain about appropriate activities or behavior. Supervisors should be models of good behavior and not participate in any harassing behaviors. Human Resources, or ICON's legal counsel, will conduct investigations. Supervisors should support ICON in its responsibility to investigate complaints of discrimination. At the conclusion of the investigation, supervisors should work with Human Resources to implement any disciplinary action and work to ensure the workplace is free of harassment. Here's another hypothetical. Jeff supervises Claudia. She tells him that a coworker keeps asking her out and making other remarks that make her uncomfortable at work. To Jeff, the situation doesn't sound like sexual harassment. Claudia wears tight clothes and short skirts and is known around the office to be quite a flirt. Jeff thinks Claudia is being overly sensitive and exaggerating the situation. What are Jeff's responsibilities, if any? Jeff should have immediately reported Claudia's complaint to Human Resources. Supervisors must report all employee complaints to Human Resources, as well as any situations they become aware of that could be considered sexually harassing. Jeff's subjective opinion of the situation is not relevant. Supervisors have a duty to maintain a respectful workplace and not permit inappropriate behavior to go unchecked. If uncertain about appropriate activities or behavior, supervisors should consult Human Resources. Under federal law, if a supervisor engages in misconduct that results in a tangible employment action, ICON is strictly liable for that misconduct. If there is no tangible employment action, ICON can assert a defense that ICON used reasonable care to prevent and correct the misconduct, or the victim failed to take advantage of the corrective or preventive measures provided. If the wrongdoer is a non-supervisory employee or a third party, like a customer or vendor, the victim must show that ICON either did not provide a reasonable avenue for complaint, or knew or should have known of the misconduct and failed to prevent or correct it. So what of the complaints about you? It would be natural to feel defensive or angry, especially if you think the complaint is unfounded. However, retaliating against an employee who reports harassment is a violation of state and federal law and against ICON's policy. You can be disciplined or sued for retaliation even if the complaint is without merit. So what is retaliation? When an employee suffers an adverse employment action for opposing an unlawful employment practice or engaging in protected conduct, for example, filing a complaint or cooperating in a related investigation, that is retaliation. Retaliation is prohibited by law. Supervisors should refrain from retaliating against any employee who reports harassment. Adverse employment actions include termination from employment, demotion, suspension, poor evaluations, or poor recommendations for later employment. Let's look at another hypothetical. Rebecca often tells her administrative assistant, James, who has been working for her for about 6 months, how attractive she finds him. James never says anything in response. Rebecca assumes he is flattered and continues saying things like, "You should wear tighter shirts so I can see your muscles," and "I bet you're really good in bed." When James learns that another administrative assistant who was hired after him earns more money, James asks Rebecca for a raise. Rebecca says that she will consider it if James goes out to dinner with her. James makes it clear that he wants to keep the relationship purely professional and would prefer not to go out with her. Rebecca says she understands, and they can talk it over dinner. While having lunch with a friend in human resources, James mentions that his boss will only consider a raise if he goes out with her, which he's dreading because she constantly makes comments that make him feel uncomfortable. Human resources investigates the comments and interviews Rebecca. Angry and embarrassed, Rebecca transfers James to a nighttime word processing position where she won't have to see him at work. Could Rebecca's conduct be considered unlawful sexual harassment? What, if anything, should James do or say in response to his boss's constant comments and touching? Does Rebecca's transfer of James constitute retaliation? The answer is yes. Rebecca's conduct probably does amount to legally actionable harassment of James. Remember, the standard is that the conduct must be unwelcome and must be so severe or pervasive as to create a hostile work environment. For 6 months, Rebecca has been regularly making inappropriate comments, which is a pervasive amount of time. Whether the comments have created a hostile work environment is based on both an objective and subjective standard. Here, an objective person would find that the sexually suggestive comments were offensive. James also subjectively found the comments unwelcome and offensive. James should not have to silently endure his boss's sexually suggestive comments, which are inappropriate and offensive. James could have considered telling his boss that her comments made him uncomfortable and asked her to stop. If he did not feel comfortable confronting his boss directly, he should have informed human resources so they could take appropriate action. And yes, Rebecca's reassignment of James could be viewed as retaliatory. James reported harassing behavior to human resources, which is a protected activity. Assuming that the nighttime word processing role is a less desirable position, James' reassignment as a result of reporting harassment could constitute an adverse employment action and is prohibited. Let's talk about strategies for harassment prevention. Employers are required to take all reasonable steps to prevent harassment from occurring, including having a harassment policy, training employees on sexual harassment, responding to and documenting complaints, and taking remedial action where discrimination, harassment, or retaliation has occurred. Now we'll move on to gender identity, gender expression, and sexual orientation. ICON is committed to providing a diverse and inclusive work environment that is free of unlawful harassment. To that end, harassment based on a person's gender identity, gender expression, or sexual orientation is also specifically prohibited. Lesbian, gay, bisexual, and transgender, or LGBT people are more visible than ever before and are increasingly open at work about their identities, but stereotypes and misunderstandings about them persist. In preventing unlawful harassment and ensuring a workplace that is respectful of all employees, it's helpful to understand certain terminology. Gender expression is defined as a person's gender-related appearance or behavior, or the perception of such appearance or behavior, whether or not stereotypically associated with the person's sex assigned at birth. Gender identity, on the other hand, is a person's internal understanding of their gender. The perception of a person's gender identity, which may include male, female, a combination of male and female, or neither male or female, and maybe a gender different from the person's sex assigned at birth, or transgender. Transgender is a general term that refers to a person whose gender identity differs from the person's sex assigned at birth. A transgender person may or may not have a gender expression that is different from the social expectations of the sex assigned at birth. A transgender person may or may not identify as transsexual, which is an older term that usually refers to a person who has taken medical steps to change the body to conform to one's gender identity. Transitioning is a process some transgender people go through to begin living as the gender with which they identify, rather than the sex assigned to them at birth. This may include changes in name and pronoun usage, facility usage, participation in employer-sponsored activities, such as sports teams, team-building projects, or volunteering, undergoing hormone therapy, surgeries, or medical procedures. Sexual orientation is a person's physical, romantic, or emotional attachment to another person. A person can be heterosexual, straight, homosexual, gay or lesbian, bisexual, attracted to people of either sex, or asexual, not attracted sexually to any gender. Some other terms to know. Gender nonconforming is a person whose gender expression is different from conventional expectations of masculinity or femininity. Not all gender nonconforming people identify as transgender, and not all transgender people are gender nonconforming. Genderqueer is a term used by some people who define their gender as falling somewhere in between or outside of the categories of male and female. Cisgender refers to a person whose gender identity is consistent with the sex the person was assigned at birth. Some examples of prohibited conduct based on gender identity, gender expression, or sexual orientation include, but are not limited to, supervisors or coworkers refusing to use the name or gender pronoun that corresponds to the gender identity with which an employee identifies. For example, intentionally continuing to call a male to female transgender employee by his male name or using the pronouns he or his, refusing to allow a transgender individual to wear the clothing associated with the gender the individual identifies with, expressing hostility to transgender, gender nonconforming individuals because they do not look or act like the employer thinks a man or woman should act, or using slurs or other derogatory terms to refer to an employee who is homosexual or perceived to be homosexual. As a supervisor, if you witness this type of harassing conduct in the workplace, you should report the behavior to Human Resources and intervene to stop the harassing conduct. Other conduct in the workplace may not constitute sexual harassment or unlawful discrimination, but it is still prohibited at ICON. This is called abusive conduct. Specifically, the law does not make workplace bullying illegal, but does require employees to provide training to supervisors on preventing abusive conduct. Abusive conduct has a negative effect on the victim of the conduct as well as others in the workplace. Abusive conduct in the workplace also harms the employer by lowering productivity and morale. ICON strives to maintain a respectful workplace. Every employee deserves to be treated with courtesy and respect. This does not mean that supervisors and employees cannot be firm or critical with each other. However, supervisors must communicate in a constructive and professional manner. A 2014 survey by the Workplace Bullying Institute, an anti-bullying advocacy group, revealed that 27% of Americans have experienced workplace bullying. 21% have witnessed workplace bullying. 72% are aware that workplace bullying occurs. 56% of bullies are bosses, but bullies can also be coworkers or customers. It is far more common for the targeted person to leave employment, either through termination, resignation, or constructive discharge, than for the bully to be terminated. Abusive conduct may include any of the following: repeated infliction of verbal abuse, for example, derogatory remarks, insults, epithets, verbal or physical conduct that a reasonable person would find threatening, intimidating, or humiliating, or gratuitous sabotage or undermining of a person's work performance. So what is the difference between abusive conduct and harassment? A single act does not constitute abusive conduct unless it is especially severe and egregious. This terminology is similar to the standard under harassment law, but slightly different. Unlike harassment, there is no cause of action for abusive conduct in the workplace. In other words, an individual cannot sue their boss or coworker or employer for workplace bullying. According to the Workplace Bullying Institute, the top 10 bullying tactics are blaming someone for errors, unreasonable job demands, unwarranted criticism, changing rules repeatedly and unpredictably, threatening job loss, insults and put-downs, discounting or denying accomplishments, excluding or shunning someone, yelling and screaming, or stealing credit or dumping blame. As a supervisor, what should you do if you witness abusive conduct in the workplace? First, you should report the behavior to Human Resources. And as always, intervene to stop the abusive conduct. For further information or questions, contact Human Resources or ICON's Legal Department.